Hello, welcome to my channel, and in today's video we shall be looking at courts and the court system in Uganda. Courts are the organs which are charged with the administration of justice. They fall under the judiciary, one of the three arms of the states. Courts are presided over by judges and magistrates. Courts administer justice with the aid of police, lawyers, and the society at large through giving evidence. There are a number of courts in Uganda, and these include the following. We have the Supreme Court of Uganda. Until October 1977, the Court of Appeal of East Africa was the final appellate court in Uganda's judicial system, and that of Kenya and Tanzania. When the East African community disbanded, the East African Court of Appeals was renamed the Supreme Court by the 1996 Judicature Statute and the 1995 Constitution. The Supreme Court is the highest court of the land and basically has only appellate jurisdiction. Appellate jurisdiction means that it entertains appeals from the Court of Appeal of Uganda and from the Constitutional Court, but it has unlimited civil and criminal jurisdiction, meaning it can handle any civil matter of any amount and can handle any criminal case of any sentence as long as it is an appeal from the Court of Appeal. It is comprised of the Chief Justice, and the current Chief Justice of Uganda is Alfonso Owinidoro, and other justices of the Supreme Court who must not be less than 5 while hearing or entertaining an appeal. This is what referred to as quorum required for the court to entertain any matter. It has powers to uphold decisions from the lower courts, reverse them, and substitute judgments or to order for a new trial. The Chief Justice is appointed by the President in consultation with the Judicial Service Commission, and so are the other judges. He is the head of the judiciary, and he is deputized by the Deputy Chief Justice, who heads the Court of Appeal. And the current Deputy Chief Justice is Mr. Richard Butera. The procedure, powers, and jurisdiction of the Supreme Court are regulated by the Supreme Court rules. Then we go to the Court of Appeal of Uganda. This is the second highest court in the land. While presiding over matters, it is duly constituted when it consists of an odd number of not less than 3 justices of the Court of Appeal. It is this court which constitutes itself into a constitutional court in accordance with the Constitution to hear constitutional cases. The Constitutional Court consists of 5 justices and handles all matters, issues, or cases concerning the interpretation of the Constitution. When presiding over constitutional matters, there must be a quorum of at least 5 justices of the court. The Court of Appeal has appellate jurisdiction. It handles appeals from the High Court of Uganda. It only has original jurisdiction when sitting as a constitutional court. Otherwise, it has unlimited civil, criminal, and constitutional jurisdiction in such matters. Its procedure and powers are governed by the Court of Appeal rules. Then we have the High Court of Uganda. It is the third highest in the hierarchy of court system in Uganda. It has unlimited original, civil, and territorial jurisdiction. This means that it can try any case from Uganda of any value of the subject matter or any crime committed and can impose any penalty conferred by law. It even has power to do anything or issue any order to further justice. The High Court also has supervisory jurisdiction over all subordinate courts and over all administrative bodies. The High Court also sits as the commercial court and has commercial division for that purpose, aimed at expeditiously settling commercial disputes. This is necessary to bring about business efficiency. Then we have the Chief Magistrates Court. The Chief Magistrates Court is presided over by a Chief Justice who possesses a law degree. This court may try all offences except those for criminal cases whose maximum penalty is death. Thus, they have limited original criminal jurisdiction. In civil cases, they also have limited original civil jurisdiction, for they can only try civil cases where the value does not exceed 50 million. They have appellate jurisdiction from grade 2 and 3 courts. We have Magistrates Court. We have Magistrates Grade 1 Court. This court is presided over by Grade 1 magistrates who must also be qualified lawyers. They are ordinarily situated at the district headquarters. Their criminal jurisdiction is limited to offences whose maximum penalty is not death or life imprisonment. Their civil jurisdiction is limited to matters where the value of the subject matter does not exceed 20 million. Then we have Magistrates Grade 2 Court. This court is presided over by a magistrate who must hold a diploma in law or be promoted from grade 3 courts. They have limited criminal, civil, and territorial jurisdiction. Their territorial jurisdiction is limited to their counties, and they are normally situated at the county headquarters. Their criminal jurisdiction is limited to any offence other than offences specified in the first schedule of the Act. In other words, it can handle offences specified in the second schedule. Their civil jurisdiction is limited to cases where the value of the subject matter does not exceed 500 shillings. Then we have Magistrates Grade 3 Court. These are the lowest courts in the hierarchy of the court system. Their criminal jurisdiction is limited to any offences other than those specified in the first and second schedules of the Act. In other words, it can only handle cases specified in the third schedule of the Act. In civil matters, they can only try cases whose value does not exceed 250,000 shillings. They are located at the sub-county levels. They can only try cases in their sub-county. Thank you for watching. Please subscribe, like, comment, and share with your friends. Thank you.